it becomes an issue of an assessment of this individual's threat to the community. That's what it becomes.
That makes him a danger to the community. People have put their appearance on the record. Well, you may go ahead.
Yes. Okay. Good afternoon, Your Honor. Robin McCoy on behalf of Mr. Mackay Nunn, who stands to my right, P63057.
All right. Is this your motion regarding bond?
Yes. Okay. Yes. So just so the court is aware, I know when I was last here, I did not have the discovery. I did receive the discovery, the paper discovery. I reviewed all of the paper discovery. I would note that there is reference to a video, which my understanding from Madam Prosecutors that they're working on getting video. As I said in my motion, Mr. Nunn, and I've known him actually all of his life. His mother worked in our office for about 10 years. His father is here. He has two sisters here, a girlfriend, and I think it's a cousin that's here. He is gainfully employed, and he has an apartment. He has no prior record, no juvenile record, nothing of the sort. As I reviewed the discovery, and I did see there are some discrepancies, and there's some things that we obviously need to look at. We are asking that.
You mean discrepancies?
Well, discrepancies. I did see what the prosecution wrote in their response. The fact that when I was reviewing the report, it said that he was not under arrest and he was questioned, and he says he was never Mirandized. And then I did see that the officer said that he, based on what he alleged is Mr. Nunn's behavior and the evidence from the video, which we don't have here today, which they referenced some things happening on a video, that they went and got a search warrant. And so then that would lead me to believe, again, I don't have the video, that there might be some issues with the search warrant, and that all that was found was the fruit of the poisonous tree. If it's what questioning, he's not Mirandized.
Okay, but what bearing does that have on his bond?
This is the first moment where Judge Simpson redirects the hearing back to its actual legal purpose. The defense is beginning to discuss Miranda issues, possible search warrant defects, and what lawyers often call the fruit of the poisonous tree. Those arguments may eventually become important if the defense later seeks to suppress evidence, but they are not the primary issue in a bond hearing. Right now, the court is deciding whether this defendant can safely await trial outside custody, not whether every piece of evidence will ultimately be admissible. Notice how the judge immediately separates future trial arguments from today's bond analysis. That distinction is critical because bond decisions focus on factors like community safety, flight risk, criminal history, and the strength of the available allegations, not whether the defense might later win a constitutional challenge. The defense is wisely emphasizing employment, family support, and the lack of any criminal record because those are directly relevant to release conditions. But will those positive factors outweigh concerns arising from the underlying investigation? And did you notice how the judge keeps steering counsel away from broader legal theories and back toward practical risk assessment? That tells you exactly where his attention is focused.
Well, I would say this. They reference certain things in the police report as a means to refute the bond. And I was not at the arraignment. I understand that the bond was set at $100,000. As I said, he has no prior record. In this situation, we're asking for a PR bond. If the court, because of the nature of these allegations, if you want to have a tether, we would say we'd have a tether, let him go to work, go to grocery store, go to doctor's appointments. I did talk to Reverend Green, and he said that he would work with him and talk with some of the other. I talked to Pastor Harold Wimberly, who works with the youth, who also said that he would work with him. But as I review the police report, I would say this too. This is not a situation. I'm not going to name the names that are in there, but they basically are talking about other people that are involved with certain activity and pictures of other people that are not him involved with activity it's not him being involved with that activity. This is a friend. One of them is a friend that he grew up with.
Okay. But I still got an answer to my question. You're saying there are internal discrepancies with?
Well, in the discovery, it says that he was questioned about I'm talking to him. It first says that he ran when the police came. He says that when the police came, he said he had worked a full day at his job, and we can get documentation to substantiate that, and that he came out to his car to get his charger, and then he was questioned by the police about where he lived, and that he says he told the police where he lived, and that he was not dishonest about where he lived. And they're also alleging that he said something about not going to the hospital. He did say that he went to the hospital to visit one of his friends from school who had been involved with the shooting, and that there was. So then the police were questioning him, and they were asking about searching his apartment, and then there was obviously some things that were found in his apartment. He said that he believes that somebody was let into his apartment and did certain things that he was not aware of, and there's allegations that the items that were found in the apartment were involved with other offenses, which again he has nothing to do with, has no knowledge of any of that.
I don't know for purposes of bond if it's something we need to get into, but who has access to his apartment?
So there in the police report, it says that he's the only one.
No, who are you saying has access to his apartment?
On the lease at the time, it's him and his girlfriend that are residing in the apartment. So it's the way the report is written is he's the only one that lives there. But at the time, it was himself and his girlfriend that lived at that. Not the current girlfriend, but a girlfriend.
I mean, am I to take then from your argument that as to what was located in the apartment, certainly during this process, you can challenge it, but he's saying that wasn't his.
Correct.
And that it belonged to somebody else who would have access to the apartment, which would mean it belonged to the girlfriend.
Not the girlfriend, but he believes that the girlfriend allowed somebody else to access the apartment, and that the other person who was involved with, what's referenced in the report is that there was some kind of shooting, and his friend Sarah calls him up and says, "Hey, I was involved in a shooting and she was at the hospital." He said he went to visit her at the hospital. She was pregnant at the time. He says that she had baby clothes in her car and she wanted him to take the baby clothes. He took the baby clothes and then he went to his apartment. And then he said she was still upset. And then she comes over there to meet him at the apartment, and he's trying to calm her down, and she's upset about the situation. But he believes that his girlfriend let her boyfriend in, and that it's the boyfriend's items that were found in the apartment, not his.
And it was who?
The boyfriend, Sierra's boyfriend.
All right. Anything else?
Again, I would just say I've known him all his life. I've never known anything like this. He did graduate from Ypsilanti High School. He's had a pretty solid work history. He worked before. I know he worked at the Noodles Company. I would often see him there. He does not have a criminal background, and his family is here. His father is here. His mother, she's working right now. Everybody is very obviously distraught. He's never had anything like this. He's upset about this because he's like, this is not me. He has assured me that this is an experience. He will not associate with the people he associated with before. He said this is one and done. I know the court, and neither of us are necessarily spring chickens. We hear stuff all the time, but
I'm a spring chicken.
I
don't know about you, Mr. Boy. You can comment on your own age, not my.
I would just ask for him, and he said he's willing to take a lie detector test as well. So I'll just put that out there.
All right, response from the people.
Your Honor, the people are concerned because this matter does tangentially involved in shooting. The defendant lied several times to the police officers during their interviews. Even the story today that's been represented by counsel is an additional new story. He first said that he went by the hospital, did not stop his car, did not get out, did not find who he was looking for and left. Then when he was pushed back by the officer who mentioned surveillance footage, he said he stopped for a minute, looked around, still didn't see her, and then left. Now today he's telling a story where he did stop, he did find the vehicle, he did find who he was looking for. He was moving stuff back and forth between the vehicle that was involved in the shooting. Yeah, this is just a deeply serious matter where I have no faith that we're being told the truth.
And Your Honor, if I may respond again, I wasn't there. The prosecutor wasn't there. This police report was written up. This is my second time talking with my client about the situation. There has been, from my standpoint, consistency where he was saying that his friend called him in distress and he was trying to help comfort his friend who was pregnant at the time and has now had a baby. And there has been consistency there. He said that at the time he was questioned, he had worked a full day, he was tired. He said that he had no intentions of being dishonest with the police. He had no idea what was in his apartment. And he said that he has had some bad experience in the past with the police. So he did obviously, I think a lot of folks have PTSD, anxiety when it comes to the police. So, but what we have is we often get reports. A lot of times I get what's in the report, and then I talk to my client. The client will say, even when they give written statements and they sign off on it, they say, that's not what I said. That's why I typically tell clients, don't say anything. Don't say anything. Tell me the truth, but don't say anything to the police talk to me, tell your mama the truth, and then just zip it when you're dealing with the police and don't lie.
You would acknowledge that were he tied to what was found in the apartment, that makes him a danger to the community.
I would acknowledge that, yes.
This exchange marks the turning point of the hearing because Judge Simpson isolates the single factual issue driving the entire bond decision. The court is no longer debating whether the defendant has supportive parents or a steady job. Instead, everything now depends on one question. Can the defendant be credibly connected to the items recovered from his apartment? The defense attempts to explain that someone else may have placed those items there, but notice the evidentiary weakness. At this stage, counsel has no witness statement from the girlfriend, no corroboration from Sierra, and no independent evidence supporting that alternative explanation. Lawyers are free to make arguments, but judges must base bond decisions on evidence currently before the court, rather than possibilities that might later be investigated. Judge Simpson is also testing credibility. Rather than accusing anyone of lying outright, he repeatedly asks what evidence actually supports the defense's theory. That is a deliberate judicial strategy. If an alternative explanation cannot be substantiated, the court is left with the objective fact that potentially incriminating items were located inside the defendant's residence. If you were the judge, would an unsupported alternative explanation be enough to reduce concerns about public safety? That is the legal balancing exercise unfolding here.
And so I've got to then go on some limb to find that he's not a danger to the community because it's found in his apartment.
Well, if Your Honor.
And if I can just finish, please.
Okay.
I don't have anything else that points to those items belonging to someone else.
Well, in the report, though, it does say that the items belong to Devon, to someone else. It doesn't say that the items belong to him.
I know.
It just says the items are found in his apartment.
But they're involved in a crime or crimes, and they are now in the defendant's possession. In
the defendant's and his girlfriend's apartment. Correct.
But how does that help me, Ms. McCoy?
If he doesn't,
If I have two people in an apartment, then are you saying that it's the girlfriend? I mean,
what we're not saying it's the girlfriend. We're saying what we believe is that the girlfriend let this other person in there, and the other person put his stuff there, put from the shooting.
Do I have anything that says that? I mean, other than the statement today, is there anything or any statement given that that scenario occurred?
I would say that we would need to talk to the girlfriend to see what her statement would be, and also talk to Sierra about what happened at the hospital. So, but I would say, again, Your Honor, I understand you. That's why we're saying if you put him on a tether, then we will know where he is. He's got to go to work.
It isn't the question of necessarily knowing where he is, although that becomes an issue. It becomes an issue of an assessment of this individual's threat to the community. That's what it becomes. And if the scenario that you have forth can give then one assessment to those items being in that apartment. But if the defendant is tied in or hiding those items in that apartment, that's a very different scenario.
Correct.
A very different analysis for the court as to what the court should do. But the part that would favor you would be if there's some indication that someone else let them in, that being his girlfriend, and that there's this other party that put these items in to his, and I say his possession because it's his apartment too, but puts it into his possession, then that becomes something very different. But I don't have that. I hear what you're saying, but I don't have that.
Right.
You acknowledge that if those items are tied to him, that he would be a danger to the public.
I would not say again, I wasn't there. I would say if
McCoy, you could try to sidestep it all you want.
No, Your Honor, I just want to make sure I'm clarifying for the record. If he was involved, if he's lying and if he was involved, what the complaint, the 123 pages of the discovery clearly, repeatedly say is that there are other individuals out there that are a danger to society. And the allegation against him is that he lied about what happened, lied about his apartment, lied about what happened at the hospital, and that there were items found in his apartment connected to what the other individuals did. And there's pictures and it's littered with indications about these other individuals. So what I would just say is that the presumption is that you're innocent till proven guilty. Although a lot of times in our society, you're treated as if you're
not going to try to give me that lecture.
Guilty till innocent.
I've been doing this way too long.
Right.
Don't try to give me that lecture.
Okay.
I just need to try to talk. I want to talk about his particular interactions.
Okay.
If all of these things had occurred as they were, and an individual, how should I say it, participates in a cover-up of those crimes.
Right.
Would you consider that person then to be a danger?
I would consider it definitely would be a problem. They're young, they're dumb. They shouldn't be, if they're an eagle, they shouldn't be hanging with the chickens because the chickens will bring you down. I would say that. He's 21, no prior record.
I hear that, but I also I understand. I'm sitting up there looking at this young man, and I realize he doesn't have a record. I realize all of those things. I also realize there's some very dangerous and tragic things that have occurred, and he has in his possession, whether jointly or by himself, the instrumentalities of those that help commit those acts.
I understand. Yes.
That's the problem.
Right.
And if he has them in his possession and participates in the cover-up of that, it really becomes an assessment of how dangerous then is this individual. Because you can be stupid and dumb and still dangerous.
Well, you can be young and dumb and make a mistake and go to jail, and then you're like, I don't like this. I'm not going to do it anymore.
Dangerous.
Well, I would say he's 21. The adult brain doesn't fully mature till the age of 26. Some people would say 30s for some folks. He has a job. He has an apartment. He said to me, all he does is go to work. He did get caught up with the situation. Even
Mr. McCoy, where would he stay if I were to release him?
if you were to release him, he could go back to his apartment, or if the court is saying, no, you're not going back there, he could stay with his parents, and they live in Ypsilanti, which I can give the court the address. I just don't want to put it on the record because of, I would rather just give the prosecutor and the court that privately. He has a sister that's in college in Detroit. He has another sister that lives in Columbus, Ohio.
So where would he,
His mom, I talked to his mom. She said that he could stay with her and his father at their residence.
Yes.
I briefly approach you.
Okay. Like we had a planned conference, I'm going to pass this matter. Mr. Coy needs to. Family in this case. So you can take him back. I'll call it up.
By the conclusion of this hearing, Judge Simpson has made it clear that this decision is being driven by risk assessment rather than emotion. Throughout the proceeding, he repeatedly acknowledged the defendant's positive qualities: no prior criminal history, steady employment, strong family support, and community ties. Those are all factors that generally favor release. However, the court must weigh those considerations against evidence suggesting possible involvement in concealing the aftermath of a serious violent offense. What ultimately weakened the defense was not simply the allegation itself, but the absence of independent evidence supporting its alternative explanation. The theory that another individual placed the items in the apartment may ultimately prove accurate, or it may not, but at this stage it remained largely unsupported. From a judicial perspective, speculation cannot outweigh the current investigative record when assessing potential danger to the community. Another important lesson from this hearing is that bond proceedings are not miniature trials. The judge is not deciding guilt or innocence. Instead, the court is asking whether the available information justifies release under appropriate conditions while protecting public safety and ensuring the defendant returns to court. Did you notice how Judge Simpson consistently brought every argument back to that single legal standard? That disciplined approach is often what separates a bond hearing from a full criminal trial. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.